is the third video in this series about capacity for fundamentals of contract law. So we're up to topic 7, and I want to talk now briefly about what a beneficial contract of service is. Why am I raising that? Well, you'll remember if you've seen the other videos that once we've got all of the elements of a contract, agreement characterized by offer and acceptance, consideration, intention and certainty, then one of the questions that might arise is whether all of the parties had capacity to contract. Now, if the subject matter of the contract is for necessaries or a beneficial contract of service, then actually the capacity of the parties doesn't matter. Because of the nature of the subject matter, these kind of contracts will be binding on both the minor and the other parties to the contract. So we've spoken in the last video about what necessaries are. In this one, I want to make sure you understand what is and what is not a beneficial contract of service. Essentially, a beneficial contract of service is a contract, an employment contract for something like an apprenticeship, a cadetship, in the old days when you could do it a lot younger, an articled clerkship, or some other form of employment where the minor not only gets a means of support but also gets instruction, education or training in a suitable trade or a profession. In order to understand what a beneficial contract of service is, it's also important to make sure that you know what a contract of service is. And it's basically a contract under which one party promises to serve the other for usually cash consideration in the form of wages or salaries. It can be distinguished from a contract for goods or services where ad hoc arrangements where goods or services are supplied. In fact, as we already know, in relation to contracts with minors, unless a contract for the supply of goods or services is a supply of necessaries, then it won't be binding. Another thing that's really important to understand about contracts of service is that contracts of service will never be able to be enforced by an order of specific performance. For example, if you have an opera singer who has promised to perform an opera but then doesn't show up on the day, she may well be in breach of contract. There may be a remedy for that, but the remedy will never be an order that requires that individual to go up on stage and sing the song. Let me illustrate these points a little bit more meaningfully by having a look at this case, Proform and Proactive Sports, a 2007 case from the UK involving the now very famous Wayne Rooney. But back when he was 15 and he was coming up through the ranks of becoming a soccer player, he signed a 2-year management and agency agreement with a company called Proform. Proform basically provided him with agency services, so that was securing sponsorship, giving him advice about certain things, arranging interviews and publicity, a range of things like that. Towards the end of the term of the 2-year contract, basically it was terminated by him and his parents, and he signed an alternative agency arrangement with a new firm called Proactive, basically providing the same services. So Proform sued Proactive. They said that Proactive had taken action to induce the Rooneys to breach their contract. And Proactive's defence was the contract wasn't legally enforceable anyway because Rooney was a minor. In response to that, Proform argued that the contract was a beneficial contract of service or a contract for necessary. So they provided alternative arguments. Essentially, when the court looked at the case, it said, well, the kind of services that were being provided weren't necessary services, and to the extent that they were services that were being provided, these were services that were being provided to Rooney, not by Rooney. So it wasn't a beneficial contract of service either. So from the judgment, the contract didn't fall into either a necessity or nor could it be analogous to contracts for employment, apprenticeship or education. Proform was neither giving any training to Wayne Rooney, nor was it compulsory for him as a professional soccer player to enter into contracts like this. In these circumstances, the contract didn't fall into the category of an enforceable contract, and accordingly it couldn't be enforced against Rooney. As a consequence, if it couldn't be enforced against Rooney, nothing that Proactive did to induce Rooney to breach a contract could in fact fall within that particular tort, because the contract couldn't be enforced against him anyway. Here's another good case that's referred to in your text in chapter 8 at paragraph 10. It also gives you some understanding, and the reason it's there is so you have some understanding of the limits of this beneficial employment contract concept. Essentially, this involved a woman who had been bound as an apprentice so she could learn stage dancing. Terms of the deed provided that she had to continue working for the master for 7 years, that she only got paid when she in fact had work to do, that the work that she was given would be at the discretion of the master in this master-apprentice relationship, that they could terminate the agreement essentially over a very long period of time if it turned out that she was unfit. Essentially, this young woman found that she couldn't actually survive well enough without seeking other work. And so the plaintiff sued the defendant again for inducing a breach of contract. And again, the defense was, this is a contract with a minor, so if it's not enforceable by the minor, that means the minor can't breach it, and that means we can't induce a breach of contract. Again, the argument that came from the plaintiff was this is a beneficial contract of service. It's an apprenticeship. This is the very kind of contract that minors are intended to be bound by. Justice Fry held that the provisions of the deed, the apprenticeship deed, were of such an extraordinary and unusual character, and I'm quoting here from the judgment, which throw or appear to throw an inordinate amount of power into the hands of the master without any correlative obligation on the part of the master. And as a consequence of that, the lack of benefit for the apprentice, it was ultimately held that this was not a contract that fell within beneficial employment contract. So in order to understand what a beneficial contract is, we need to remember that two parts of the test. It needs to be beneficial to the minor, but it also needs to provide some sort of training or induction into a profession and supply them with a living. So let's go back to our framework. In a previous video, I've gone through this idea of necessities or necessaries, but basically each time we ask ourselves this quick question: are all the formation elements there? In other words, do we have everything that we need to demonstrate that there is a contract? If we do, and the contract is a contract where one of the parties is a minor, then we need to ask ourselves, is it a beneficial contract for employment? In other words, does it meet that test that I was just talking about? Are there benefits for the minor, both in terms of training and instruction and moving towards their chosen career or profession? And does it supply them with a means for making a living? If it does those things, then it is binding. If it's binding, then it can be enforced both by and against the minor. So let's then take a breath, go and have a drink of water, stretch your legs, do what you need to do, and in the next video I'm going to start to talk to you about what the consequences are of incapacity when we're talking about other kinds of contracts, not necessarily those for necessities or for beneficial employment. See you on the other side.